Hello and welcome to Moneylife. This is Sucheta Dalal. This week, we are going to talk about Patanjali. Yes, I'm sure all of you have seen the headlines and what happened in the Supreme Court. The question that I'm asking this week is, will the Supreme Court finally put the brakes on Patanjali's decade-long misinformation spree? And indeed, I do believe that they have been issuing misleading ads, not for a short while, but at least for the last 10 years. So let's start with what happened yesterday. So on 2nd April, the court proceedings indicate that the Supreme Court may finally act against Patanjali Ayurved's misleading advertisements. The court was furious yesterday and had a lot to say. In fact, yesterday was the day that Baba Ramdev and Acharya Balkrishna had to be personally present in court. A lot has happened before this, and they were supposed to tender an apology. They did tender an apology of sorts, but the court wasn't satisfied. In fact, it was incensed at the perfunctory apology submitted by the Patanjali founders. It even called it lip service and humbug. That's how angry the judges were. Justice Hima Kohli and Justice Ashaduddin Amanullah is the bench that is hearing this case. They refused to close the contempt proceedings that they had started on 21st March against the duo and have posted it for 10th April, where they are supposed to come up with a better affidavit of apology and again make a personal appearance in court. If they do that, hopefully for them, the contempt proceedings will be buried. But let's see what else happens. Point is, you have to look at the larger story. Before we come to that, why did it come to this pass where the Supreme Court is so angry? Did Patanjali's legal counsel underestimate the severity of the SC hearing on 19th March, 21st November 2023, where naturally Baba Ramdev and Acharya Balkrishna were personally asked to attend court and were clearly told to put an end to the misleading ads? In fact, the court even threatened to impose a cost of 1 crore for every false claim about curing diseases. Now, the question is it about this one case or is there a pattern to this behavior? Remember, Patanjali as a group today has a massive advertising budget. It has enormous control over mainstream media narrative. They're forever giving interviews, especially to the large Hindi-speaking mainstream media. Foods is the only listed entity. This was formed when Ramdev and Co. took over Ruchi Soya and merged it with an unlisted business that they had. The market capitalization of this company alone is 50,000 crore. Its total income in 22-23 was 31,821.45 crore. This is one part. Very little is known about its non-listed businesses, which are equally huge. But we know that the group has money for massive advertising across the spectrum, the English media, all the language media, and most importantly, Hindi television. There is a pattern of Patanjali ignoring judicial warnings, employing litigation as a tool, and issuing misleading ads. When cornered, even this time, Patanjali tried to blame its media center for failing to halt the misleading ads. Yes, indeed. Even after the Supreme Court order, they had not stopped the ads. And in the affidavit, they tried to blame it on the media center. But the judges knew that Baba Ramdev had rushed off and held a press conference within 24 hours after the last court hearing. So he was fully cognizant of what the court had asked them to do, which is why I suppose the Supreme Court was so angry. Now, everybody recognizes that Baba Ramdev's promotion of yoga, the revitalization of Ayurvedic treatments has been good. It has been good for the country, has been good for the people, and everybody recognizes and respects it. The judiciary has said so itself. However, the company's rapid growth in the last 10 years is not only about yoga. It also owes a great deal to its aggressive marketing strategy, its advertising campaigns, which portray all their products as good Ayurvedic, herbal, natural, while everybody else is bad. And this is not just medicine, but across a range of products. Let's first come to this particular petition. This one was filed by the Indian Medical Association, which, when it filed the petition in 2022, sought directions from the Supreme Court to the central government, the Advertising Standards Council of India, which is like the advertising watchdog, the Central Consumer Protection Authority, CCPA, newly created under the Ministry of Consumer Affairs, to act against these misleading ads, promoting the Ayush system while denigrating allopathy, which is considered evidence-based medicine. And in particular, at a time when you have just gone through a global pandemic, all their ads and their comments about the COVID vaccines. They laugh at COVID vaccines, they promote their own product, they talk about how doctors have been dying. And obviously, the Indian Medical Association decided that they can't stand by and allow this to happen. In fact, it's exactly what the judges are so angry about. Point that you have to ask is, why would anyone have to approach the court to get the government to act? Isn't it the government's job to act? Well, precisely because the government was doing nothing. It had been silenced, like the advertising watchdog. ASCI has been silenced since 2016. In fact, where this court case and warnings are concerned, it began with August 2022, when both the Supreme Court as well as the Delhi High Court asked the company to stop misleading people. That was the time when Chief Justice N.V. Ramanna headed the apex court, and he said, and I'm quoting, "What happened to Baba Ramdev? He can popularize his system, but he shouldn't criticize others. We respect him. He popularized yoga, but mustn't criticize other systems. What is the guarantee his system will work? He cannot refuse the doctor system and must exercise restraint." Now, smart people would have taken the hint. The bench changed. The yoga guru and the Patanjali mascot remained unconcerned. Around that time, the Delhi High Court had objected to Patanjali's claim of having found a cure for COVID-19. Frankly, the enormity of the COVID pandemic and the continuous mutations of the virus still exists may have focused sharper attention to the impunity with which Patanjali has been making false and misleading claims and getting away with it for a very, very long time. But there was a time until 2016 when ASCI, Advertising Standards Council of India, the advertising watchdog, did do its job of upholding complaints against Patanjali. Consider these examples. So Patanjali has its Kachi Gani mustard oil. In 2016, its ads claimed that competition was selling adulterated mustard oil with a neurotoxin called hexane, but couldn't substantiate its allegations. ASCI called this grossly misleading by exaggeration. The complaint, among others, was filed by the Solvent Extractors Association of India. They not only complained to ASCI, but also to FSSAI, which is the Food Safety and Standards Authority, seeking action. Patanjali claimed that its ads were based on research, but did not present it convincingly. In Jan 2018, in fact, FSSAI had asked the Central Licensing Authority to issue a show cause notice to Patanjali. Nothing much seems to have happened. Patanjali Dugdamrut. This is the second case. In April 2016, ASCI upheld complaints against this, which is a cattle feed. What did it say? It said other companies mix 3 to 4% urea and other non-edible things in their cattle feed. There were also vague references to rising infertility among cattle and butchering of cattle, most of it unsubstantiated, so complaints are upheld. What happens when the complaint is upheld? The ad has to be removed. Unfortunately, ASCI is pretty toothless. All that happens is ads have to be removed or the campaign has to stop. So whatever has happened in the past is done and gone. No new ads can be put out in the press or on television. Third, Patanjali Dantakanti. This toothpaste brand claimed effectiveness against pyorrhea, swelling, bleeding gums, yellowing teeth, sensitivity, and bad breath. Unsubstantiated again. Not only this, it also made claims. Its ads said things like "Safed coat pehen ke safed jhoot," which is white lies from people wearing white coats, referring to dentists promoting the benefits of toothpaste. Patanjali fruit juice claimed that others are expensive and contain less fruit pulp. Complaints upheld. Now let's come to soaps. Wide spectrum of soaps. It attacked the multinationals again, mainly Unilever and Rickett and Coleman. Unilever's three products. One was Lux Soundary Sabun, as we know, promoted by film stars, Lifebuoy, and Pears. Now, in 2017, Hindustan Unilever decided that it won't bother with ASCII. It went to court, secured an injunction against Patanjali for disparaging its soap brands with claims like, when I tell you the slogan, you know how disparaging it is. Film stars ke chemical bhare sabun na lagao. About Lux. Favorite of film stars is the very, very famous catchline of Lux. Then Pears, glycerine soap, no tears. So it says, tears badhaye fears. Lifebuoy, it says, life joy, not love near. Well, none of this has to be substantiated. It was simply disparaging and not allowed by the ASCII Code of Conduct. The same year, Rickett Sir also got an ad interim injunction from Delhi. In fact, it had demanded a 2 crore defamation from Patanjali. This was about the Dettol soap. Soon after, Dabur India got a restraining order against Patanjali from the same court for disparaging its Chyawanprash brand. Now, the number of complaints being upheld and reported by the media was rising to embarrassing levels, and other issues were cropping up because Patanjali was huge and was attracting public scrutiny. So someone tested its ghee and it reportedly failed a food safety test. It was accused of post-dating its products, which means you get the product in the market today, the manufacturing date may be 15 days later. So it wants to stretch the shelf life of its products, the use by date, and that's why it was post-dating its product. A magistrate in Hardwar also ordered Patanjali to pay 11 lakh for releasing misleading ads and selling products manufactured by others with its label. Things then reached Parliament, and a question was asked in Parliament in July 2016. Responding to a query, the then Minister of State for Information and Broadcasting, Rajavardhan Rathore, had given this answer. He said complaints had been received against 33 advertisements of Patanjali in the past year, which was period April 2015 to July 2016. Further, 17 out of 21 ads, the complaints were found to have violated the ASCII Code of Conduct or Code of Advertising. And 6 were about packaging, claims made on the product packaging, not the ads. So 33 complaints, in fact, had been upheld. Now, while ASCII is seen as a self-regulatory body, it works closely with the government, as is clear from Mr. Rathore's answer to the same question in the Lok Sabha. He said the ministry had assigned the task of handling complaints received on its grievance against misleading ads, GAMA, it's called GAMA portal, to ASCII. If advertisers do not comply with ASCII orders, then it is referred to the ministry for taking appropriate action. This is important in the context of what happened next. Now, after things reached Parliament, obviously, Patanjali was furious. It used its extensive media access and went on the offensive. Lots of interviews, and the managing director, Acharya Balkrishna, said there's a conspiracy by multinationals to tarnish Patanjali's name. In fact, it went ahead and filed a defamation case against ASCII, obtained an ex parte stay, and also claimed that it was not a member of ASCII, the advertising watchdog, and hence not accountable to it. Now, this stance clearly is contrary to what the minister told Parliament. So why didn't the ministry take it up further, especially when there was an ex parte order against ASCII and ASCII had effectively been silenced? Patanjali instead complained about the timing of the complaints and said, why didn't anyone complain for 15 years that we've been in existence? The answer is simple. First of all, Patanjali was established in 2006. It's been around for less than 20 years. It gained national presence and advertising muscle much later. In fact, not more than 10 years, 8 to 10 years. So people begin to complain when your ads go nationwide and you are noticed, and if you're saying something wrong, there is a complaint. Interestingly, ASCII and the Ministry of Corporate Affairs and FSSAI have remained silent since 2016. They could have followed it up, they could have appealed, they could have done something. After all, the ministry says that they're going to take up things if people don't listen to ASCII, right? Nothing happened. In fact, despite IMA's request for directions to ASCII, ASCII did not implead itself in the Supreme Court matter that is going on. When asked, even today, it just says everything is sub judice. It claims it made efforts to vacate the stay, but essentially has been quiet for 7 years while Patanjali has continued with its misleading ads. Now, the SC hearings have, especially because of the toughness with which the judges are dealing with this matter, seems to have changed things. The New Indian Express reported on 5th February that the Prime Minister's office has directed the Ayush Ministry to act appropriately against Patanjali for continuous violations of the Act dealing with misleading advertisements of Ayush products. The company has repeatedly claimed that its medicines had zero side effects and are 100% effective. Now, the Supreme Court's resolute attitude to uncovering the truth, like I said, is making a difference, because on 2nd April, the court did not stop at questioning Patanjali. It also questioned the Ayush Ministry. It asked about its silence on the efficacy of Ayurvedic products in treating COVID. In fact, Justice Kohli also questioned the government on its failure to act against Patanjali's disparaging assertions against modern medicine. What is the point in pretending to have a watchdog called ASCII, a tie-up with the Ministry of Consumer Affairs, if it remains silent for 7 years and does nothing? What is the point in having a watchdog if people have to go to court and bypass ASCII and finally reach the Supreme Court to even hope for justice? It's not the end of the matter. There's a hearing on the 10th and the order will follow. So we're still at an interim stage. Undoubtedly, a SC ruling, but there is a strong ruling on the IMA case, will reverberate across the product range, at least as far as this one group is concerned, which has got away with evading the consequences of its actions and its audacious claims for a very, very long time. If you agree, share this video. Like you, I was a user of Dantakanti and a whole lot of products of Patanjali until you saw that the products and the claims weren't as honest as they ought to have been. Share it, because a lot of people do use the product and we need fair advertising. Thank you.